enjoy the class.
Hi, everybody. Welcome to Advanced Healthcare Planning. The Reverend David Blau majored in psychology at Hope College, has a Master of Divinity degree from Western Theological Seminary, and a Master's in Counseling from Loyola University of Maryland. He did healthcare chaplaincy training at the University of Chicago Hospitals and the Johns Hopkins Hospital in Baltimore. Ordained in the Reformed Church in America, he has served Blauenberg Reformed Church, no kidding, near Princeton, New Jersey, where he worked as a staff chaplain at the Medical Center at Princeton. He's a board certified chaplain in the Association of Professional Chaplains. And since 1994, David has been the leader of spiritual care services at Holland Hospital. More recently, David has joined the board for Making Choices Michigan, fostering conversations about healthcare decision-making and end-of-life care. Please welcome David Blau.
Thank you, Tom. I appreciate being here, and thank you for your invitation, Tom. Not a lot of people say that advanced care planning floats their boat, but this kind of floats my boat. I like doing this as a little avocation, along with my other ethics committee responsibilities at Holland Hospital and my chaplaincy duties for our department here at the hospital. And so I've spoken to HASP groups I think one other time on advanced care planning, and then a couple other topics over the years, but they all kind of blend together over time, and I can't remember exactly what they were, but they were in person, and you all look better in person, but you don't look bad on the screen either, and I'm glad to be here in that way. So I'm going to ask Susan to put up the PowerPoint, and if it's not up already, do you see it? I don't see it.
1 second, I'm sorry, I'm usually faster on the draw, but give me one moment. I just had a little glitch, which is a nice thing to hear when you're the speaker, right?
Not a problem. I will guarantee you there shall be glitches, because as I said, I'm not an expert at this at all. I'm not like a college or high school or middle school teacher, and I don't have this down yet. So we're all working about this. I've enjoyed my work as a spiritual care chaplain here at Holland Hospital. We're still very much in the middle of our pandemic, and as you know, numbers are slightly rising again, and it's cause for concern. So we are very glad that the community in general is still a virtual community in many ways, congregations and otherwise, including HASP, and I think that's a wise move for the moment. So
let me just, and forgive me, people, when we spoke yesterday, you were going to share the PowerPoint yourself because of the
yeah, I guess it's something that I need to do, isn't it?
Yeah, and but I do have it up, and I absolutely can share it, but we had talked about the timing of the
So
There we are.
So yeah, perfect.
it's my point exactly, that I don't know what I'm doing exactly.
No, that's, hey,
Yes.
my heart skipped a beat there for a second too.
Yeah,
Okay.
I'm sorry. So the point of this time is to reiterate some things that you probably already know. Let me just say off the bat that I'm realizing that probably the majority of you here on this session have an advanced care plan. It might have been done in estate planning. It might have been done, by your own lawyer, and that's great. Nothing that I'm going to say either today or next week at this time is going to say that that is illegitimate or you should do it over or it's not kosher. It's really just fine, whatever document you have. The most important part is going to be talking about how you appoint, if you haven't already, a patient advocate, a spokesman for you, and for healthcare things, that is, of course, and how you talk with them ahead of time. No good to have it on paper and have the person chosen, but not having talked through your values and issues and goals. So you're going to hear me say that about 10,000 times, that the main point is talking. And the main point is conversing about things that are not easy to converse about. I'm not trying to be a lawyer here. I'm not a lawyer, and I'm not giving legal advice. I joke, my twin brother Dan lives in Grand Rapids, and he is a lawyer. So I say I don't play what he says. I don't play a chaplain even on TV, and I don't play a lawyer, and nor do I play a doctor, Tom. I'm not trying to be so clinical that I'm trying to impersonate medical advice, or these are my disclaimers as far as my ethics conflicts that I might have to choose. But whatever I'm saying here is born out of the fact that our healthcare ethics committee here at Holland Hospital is the group which is made up of many disciplines, including physicians and lawyers and others of all different chaplains and social workers and nursing and everybody else. And we are the committee at Holland Hospital, which is given the responsibility over advanced care planning and what form we use as a hospital and how we instruct patients to execute a patient durable power of attorney for healthcare. So although it sounds like I'm using legalese sometimes because I'm quite familiar with it, this is not formal legal advice. Our presentation objectives are to look at the basic framework about healthcare decision making and what advanced directives are and what they're not, and why having an advanced directive may be your best interest, or dusting it off from the drawer that you pull it out of and say, I did this 10 years ago, what the heck does it mean? And what should it mean for my healthcare decision for now or for later if it comes into effect and affects what decisions are made for your healthcare if you could not make decisions for yourself. And it's to answer your general questions about how you get started with this, or how you interpret the document you already have, or to look more specifically at the points of conversation, the talking again, that you will need, in my view, to do with your patient advocate, your surrogate, your decision maker. Some of the theory behind everything about advanced care planning, the first law, statute in the state of Michigan, which came out of 1991's federal law, Patient Self-Determination Act of Congress in 1991, said basically patients have the right to get the care they choose. Not what the doctor chooses, not what your daughter chooses, not what everybody else chooses, but what you choose. That got rolled out into the Michigan statutes in about the same time, 1991, 2, 3, somewhere in there, where then they gave it legs for the state. The theoretical background of this is patient autonomy. Fancy word for I get to do what I want as I see it, as I see fit, not as you see it for me. And that's of course a Western civilization, very basic, very bedrock. I mean, that's the cause of all of our individuality arguments as a society. You can't tell me that I can't open my restaurant. You can't tell me that I have to wear a mask. You can't tell me that I have to get this vaccination. You can't tell me that I have to go to that hospital. I mean, this is the American individualism kind of rolling out in the culture on a consistent basis since probably 1740, even before the revolution, and before they threw the tea bags into Boston Harbor. We have picked that up as a theoretical basis as a Western society, Europe, Western societies otherwise, saying that patient autonomy is the essential, central, ethical principle in good patient care. And most of us would not disagree with that. We don't want somebody else having to be the boss of us. We want to be our own boss. We want to be our own decision maker. And that's part of the American ethos and the American milieu all around us. But the principle of autonomy runs this discussion. Just to mention the other ones, there's 3 or 4 other basic ethical principles that we use to structure our society. The one is, we know, it's a fancy $10 word, non-maleficence, which is basically do no harm. That's an ethical principle we judge on in making decisions in our society. And the beneficence, the other side of that, is that we're going to try to do good. That's an ethical principle. And there's 2 others that are basic principles. The principle of justice or fairness drives a lot of what we as a culture do, and the ethical principle of equity, which is they sometimes call distributive justice, or a sense of is this right for the society? Is this right for the wider, bigger picture, as opposed to my own individuality in that way? So a lot of these ethical principles, but mostly autonomy, is what is driving some of this idea of advanced care planning, patients' right to self-determination. So here's top 3 reasons to do an advanced directive, in my opinion. Reason number 3, all adults should think about and appoint the best healthcare spokesperson for you to know. And I guess that's a spokesman for healthcare, not a healthcare spokesperson, not a doctor or a nurse. But to know ahead of time who would be your voice if you were injured or incapacitated and couldn't speak for yourself about your health care. That's a base. Number 2 reason why you might want to do a document like this, or have chosen to do it. Talking about your values and goals for potential treatment decisions is a gift to the people you love. They won't have to guess what you would want if the time comes when they're your spokesperson, they're your voice, because you will have made it clear, at least as you know it now, of what their values that would drive a specific healthcare decision. We'll get into a lot more detail about that. And then reason number 1 might be setting up a durable power of attorney for healthcare. Doing it now, and as you can see in my parentheses here, it's a little confusing, because if you go state to state, region to region, you're going to hear it called all kinds of different things. In Michigan, we call it durable power of attorney for healthcare. Other places, you might see it referred to just as POA, power of attorney, and they assume healthcare, and that's not financial power of attorney. Or DPOA for healthcare. Some people in the literature will call it surrogate decision maker. Some people in these forms will call it your agent. Some people will call it your patient advocate. That's the one that Michigan uses. They want us to use in Michigan. They want us to use patient advocate. So all of these forms are basically trying to talk about what would a patient advocate, duly and legally assigned by you and accepted by them, have to say about healthcare decisions on the table. So healthcare, setting up a durable power of attorney for healthcare now is like executing a will, for financial or property things, or buying insurance, or it takes the pressure off for all if something bad happens later. So that's a reason why I believe that all adults 18 and over should consider having a potential spokesperson in the wings, only if we were unable to do that autonomous thing, which is to make our own healthcare decisions in the way we best think they should be made for us. For instance, I'm going to give, but before I get to some for instances, does anybody have a question or a comment? Just unmute yourself and say it if you'd like, about some of the ethical principles, or some of the autonomy, or the reasons why we do this. Hearing none, I'll give you a couple for instances. So now I wrote these before in conjunction with some training we did for the emergency department at the hospital. So these are kind of from the perspective of a hospital employee. You're going to have to translate a little bit. But you'll get the idea of it. For instance, a 90-year-old with no documents, like no healthcare, advanced care planning documents, arrives. That person, 90 years old, is unresponsive, who knows why, from home. They were at home and healthy until they came in unresponsive on the ambulance. And the initial assessment is that they have an aneurysm in their aorta running down the middle of their back. It's not a highly survivable AAA, as they say. And there's no family there with them. I don't know what happened. Maybe they got picked up. They fell over in the backyard. They were picking up a weed like my 98-year-old neighbor does sometimes. And they fell over. They called the ambulance. They arrived there. There's no family or loved ones with them. So should they begin? This is not a highly survivable thing with a 90-year-old, but should they send them to the CTs right away? Should they not? This is an easy one. They should. There's no directive. So they're going to do everything they can do to save life if they think it's a life-threatening situation. And they're going to send them out for a workup. They're going to do the CT scans. They might do an MRI. They might do whatever they need to do to figure out what's going on with this 90-year-old. But how is the decision-making capacity documented by this staff? And they say this person does not have decision-making capacity. They're unresponsive. And so here's an instance of what are we going to do when somebody who does not have a directive shows up on our doorstep? And that's kind of an easy one. We do everything until otherwise noted. That's the way hospitals work, and that's the way AMR and life ambulance works. They do everything for life-sustaining treatment that they need to do, and they sort it out later if you need to sort it out and somebody says, back off, we don't really want that on whatever basis. And then we'll get into some of that. Here's another example. So let's say an 85-year-old who is living in a skilled care facility. They have a do not resuscitate sheet from their facility, but let's say it's one of the local facilities, and they have their own in-house code status sheet. But this person, 85, arrives unresponsive. They're not able to tell us what they want. And their next of kin, who is the durable power of attorney for healthcare, patient advocate in this case, they do present in the ED. And the patient advocate does not have the advance directive with them. They just say, I'm mom's durable power of attorney for healthcare. I know she wants this. I know she wants that. What is the patient advocate requests that say, we call it code A, which is do everything in a life-threatening situation to preserve life. But there's no proof that the daughter or the son is their advocate. It gets a little dicey because then you have the sister show up that says, I'm the advocate. And mom told me last week, I do not want to have life-sustaining ventilators and pounding on my chest and et cetera, if it should come to that. So now we have a little conflictual situation. If the next of kin and the next of kin cousin or brother or spouse shows up and says, I know exactly what they want, but they don't know. Here's another instance. A 40-year-old patient has a sudden stroke. And unfortunately, we had a 34-year-old last week who had a sudden stroke and was shipped off to Butterworth in a life-threatening situation. So it happens with younger people. It happened 1 hour ago. They arrive at the ED by ambulance with the spouse and the advanced care document that names that spouse as the patient advocate. Okay, we know who should be talking to about that. The wife declines treatment that the medical staff they have this clot busting drug that if you get it within X amount of time, in this case, 1 hour would be within that X amount of time, the doctors tell me, that would possibly reverse even a severe stroke if it was an ischemic stroke. And so, but the wife declines She's the advocate. She's got the paper. Shows that she's the advocate. She accepted to be the advocate, but now she says, don't do that. Should that patient advocate's decision be honored is a question that might arise. Are you asking a question, Tom, or are you? Okay. Here's another one. I got 5 of these, so there's one more after this, just by way of example here in this part. So let's say an 80-year-old comes in with chest pain they rate as 8-10. They arrive from a skilled nursing facility. They don't have an advance directive document, but they, with a physician assessment that he has early onset dementia. And the patient says, I'm going to be fine, but if it's my time, God will take care of me. He's even joking a bit, commenting on the pretty nurses. I guess they call that sexual harassment these days, but that might be the truth in that way. But upon informal, real-time assessment, he rates low in decision-making capacity. And the way they do this is that if there's a question, they might do the thing called a mini mental, which is a series of 10 questions that a social worker might ask to try to assess how much this person is living in the present, understands what's happening, knows, you know, what's in front of them and what's going on. And so that's say that that's done, but has rated a low rating on decision-making capacity. A bit later, he says, it must be my time, doc. Just let me go. Be with God. I miss my wife so much. And so he's a candidate for a heart cath. He's come in with his chest pain. They discovered there's a narrowing artery. They want to go in, take a look, possible do a stent. And no family is present. He's come here from the skilled care facility. And should they proceed with the heart cath? Wait for family to arrive? Just go? You know, these are clinical dilemmas that healthcare staff face when there's not kind of appropriate, reachable, knowledgeable patient advocates about what this gentleman in this case would want. Last one. Let's say there's a 75-year-old on a bus trip here from Tulip Time and kind of goes over in the street eating oily bolin or whatever they call them. And so they're unresponsive, but the ambulance brings them here in what we call a priority one. The first whisk them off to CT, which is usually the first thing to see what's happening, and outside of the heart echocardiogram and that kind of thing, or I mean the EEG, that kind of thing. So the first assessments through imaging show either the brain bleed or maybe a growth or a tumor in the brain. And her tour companion says she has a living will from Illinois and says they even talked about it. She was told where to find it in her suitcase. She brought it with her. And the friend who's been traveling with her up from Illinois for Tulip Time, she has the document in hand. It's a living will. Okay? And it reads, I would never want life-sustaining treatment if I could not regain my ability to enjoy life. Okay, so you're the decision maker clinician about what to do or not to do for this relatively younger person here who's on the bus trip from Illinois. That's an actual one that happened. I was there when that happened, almost exactly like that. So here we're got some real life examples about how directions are often needed with healthcare decisions, and for people that may or may not have put in verbal or written instruction. Healthcare treatment decisions are often complex. They're not automatic. And the autonomy principle tells us that we are the best people to decide what we might want or not want. I agree with that, as most of Western culture believes. Family and friends need direction and instruction ahead of time about your values and goals for your healthcare. So that's kind of, why we're doing this. The best way to assure treatment decisions and reflect your wishes is to appoint what we call in Michigan a patient advocate. There's other names that could be used as well, as I mentioned.
Can I stop you before you take another step, David?
Go for it.
It's Bob Kenny, and I think my video is not on. But one of your scenarios I found interesting. You've got the 40-year-old, his wife is the POA, and she's got the document, and she's declining treatment. How is that an issue for the hospital if the patient's unresponsive, the POA who's got a document, and I'm assuming the document allows her to choose the treatment she chooses? How does the hospital even get into it? I mean, I don't want the hospital to respond with some ethical duty if my document says something different.
Right. And it's mostly in the realm, I think it's an excellent point, and it's mostly within the realm of what we call moral distress. Nurses and doctors have what they call moral distress. And it is, I know I could fix this and get back to life as relatively normal, but they're refusing it. And that feels like I can fix this, I can do something to help this, and they won't let me. So that's a frustration, that's a kind of a cognitive dissonance. And so it's not so much a what should we do, it's, oh, we have to do that. I mean, they would probably honor if she could, if the patient advocate, in this case, the spouse, said, on the basis of this and this and this, I know that in this situation, he has instructed me, he's let me know ahead of time that this is a situation where it could fix it, but it might not fix it, and I don't want to try. And then it moves more into the realm, what we would call in our ethics committee, substituted judgment, an ethical thing, so that I'm doing what I'm imagining what my loved one, my husband, would say about this. And I'm duty bound, say the documents, to do what I think that under autonomy, what he would want. And even if he knew he was having a stroke and it could get reversed and he'd have slight ramifications for his next 15 years or whatever, he doesn't want this. And if she could if she could persuade, that would help the moral distress that the healthcare team would be feeling. The other point is informed consent, and that is with decisions in healthcare. Anyone that's in medicine knows that it's all important to get informed consent, so that person knows what they're dealing with, and or their surrogate or their advocate knows what they're dealing with and is making a clear-headed decision that they can rationalize and explain to someone else of why they would or would not want that. So, and under informed consent, we would say, well, maybe this wife doesn't, I forgot if it was wife or husband now, maybe they don't get it. Maybe they don't get that the TPA treatment could break up this clot in his brain, and in 3 days, he might be significantly awake, walking around, feeling good. We've seen that happen. I mean, that's a wonder drug if you get it within X many hours of a stroke. So, I think as long as you had informed consent where they understood clearly, and the person was seriously doing substituted judgment, what they know that person would want, they would follow their wishes, but they wouldn't feel good about it unless, even if maybe they understood through information what the situation was, they would still feel uncomfortable.
It just strikes me, I appreciate what you're saying, but it strikes me that I don't mean to say it this way, but why bother going through this if my POA for healthcare has got to prove to somebody that that's what I want?
The ethics of the clinician, in this case, let's say the ER doc that wants to start, or the neurologist that wants to start the clot busting drug, they've got to know that that person understands the ramifications, if and can do that. If they're not concerned, then it's back on them. And not concerned, but if they're not clear, some of the responsibility falls back on the clinician for making that adequately known. And so it is a dance that happens, and it's not just a, well, she said this at breakfast 3 days ago, so let's not do this. Let's let him go. Let's let nature take its course. It is a bit of a dance, ethically. We have an ethics consult about it, possibly.
Thank you very much. I appreciate it.
David?
Yes.
If someone is in a skilled nursing facility and they have a DNR, why are they taken to the hospital?
That's the big question that I wish I could tell you how many times that's exactly what's said when they arrive here. We've got this paperwork here. Why are they here?
Right.
And it's a matter, and I know that long-term care and skilled care is a very hard place to navigate the morphing understandings of do not attempt resuscitation.
Yeah.
But by and large, it's because people want to err on the side of caution when it's a life and death situation. That's my view, is that if there's, sometimes it's just middle of the night confusion and the paper didn't get right in the chart. That happens a lot. Now, we've got great skilled care facilities in Holland. I mean, there's some that may not be great, but there's several great ones. And even they sometimes send a person with a DNR, and because some glitch. And our goal is to help that be better.
Yeah. Okay. Thank you.
So unfortunately, injury and diseases happen, sudden events, and people of all ages. There's aneurysms, there's motor vehicle things, there's brain injuries, there's terminal illness or progressing illness or chronic things, and even young people fall victim to life-sustaining treatment is needed, and decisions need to be made. This is an old cartoon, maybe you've seen this before, but the playing God point, you know, we've got artificial everything here, and the person's on all this, and it says somehow through their voice or through their paperwork, let me die. And what? And play God? So it's that playing God point. Who is playing God in healthcare decisions and that. What if loved ones disagree? We've referred to this before. What should they do for you, especially if they disagree? And it gets messy quickly. It just does. People get messy quickly. And how can you head off maybe family conflict and disagreement? You know, the classic case is that Terry Schiavo case from Florida, 20 years, who knows how many years it's been, 18 years ago or maybe more, around the time of the election when the second Bush was elected, and Al Gore and all that. And then they had the big case about Terry Schiavo in Florida, who had anorexia. She had a heart attack when she was in her late 20s. She was in a persistent vegetative state for 8 years. Her husband and the patient's, Terry Schiavo's parents, disagreed about a feeding tube for her. She was not on respiratory support. And the husband wanted it removed and to let her go. And the parents took it to the Florida Supreme Court, later to the Supreme Court of the United States, and even a vote in Congress about her outcome and whether they could technically take out her feeding tube and let her die, as some would say, naturally, in that way. And that would have never happened if she had an advance directive. If she had a sign to say, I want my husband to make the decision on this, I want my parents to make the decision, my mom, my dad, anybody else you choose. It didn't have to be family. You don't have to be family to be a patient advocate. It's whoever the patient chooses to be their advocate, patient advocate. So, we can undo a lot of stuff, even though it's messy. Advanced care planning is not one and done, but a process. And I'm going to ask Susan now to put up this document called Advanced Care Planning Process.
I will do that right now.
That's one of them that I think was sent to you by Kim maybe last week. One of 2 documents that came first to you last week. And you can look at it in hand, or you can look at it on the screen when it comes up. This is part of a document of Making Choices Michigan. This is not published yet. In fact, the 2 documents that were sent to you last week are both not in active use yet, and that's why they say final. They say final draft on them, but they don't say done deal. And there's some typos in them, and there's some I couldn't get the one that was the last one. This is the one that was the last one before they're going to make it official, and it's going to be started to be used in the state of Michigan. I'm told by April 1st, which is next Thursday. So we'll see if it actually happens or not.
Are you seeing my screen?
I am, but your bright margins cut off just a little bit.
Okay, let me expand that a little bit. And I'm going to make one suggestion to you. I think something that is around your hands or your computer is bumping up against your speaker.
Oh.
And so we're getting some clicks and feedbacks. I do that a lot when I talk with my hands. So just
okay.
Now, are you seeing the full screen?
Yeah.
Okay, now I'll move down the screen as you instruct me to.
Okay. So this is not something that I want to read in depth or in detail. I want you to kind of scan through this form. And again, part of that repeating myself 7 times is an adult with the ability to make your own medical decisions. You can accept, refuse, or stop medical treatment. If you lose the ability to make your own medical decisions, for instance, because of an accident or sudden illness, someone else will have to make those decisions for you. You can choose the person you want to make reasonable steps to follow your preferences and instructions for care. This person is called your patient advocate. You should thoughtfully identify your personal values, beliefs, wishes, and treatment goals regarding serious illness and end-of-life care. And your patient advocate needs to understand that your treatment goals and values and is willing to act on your behalf if and when necessary. In Michigan, 2 physicians or your attending physician and a licensed psychologist, not a limited social worker, MSW, but a psychologist, have to examine you and declare that you lack medical decision-making ability, making decision-making capacity, it says, before they may act on your behalf. So what I'd like to have you, as you scan down some of those bullet points there, I want you to just kind of look at any one of them that maybe you have a question about, or you're wondering about what that means, and we'll address it in that way. The 2 physician thing is the state law. Now, if you're unconscious, you don't need 2 physicians to tell you you're unconscious. They know you don't have. The questions come up was when you're able to converse, but people aren't sure you're really comprehending what situation you're in. It might even include somebody who has early stage dementia, who's having a bad day and is really not able to make their own healthcare decisions. But 2 weeks later or 2 days later, they may be able to make their own healthcare decisions. And it's a little, what's the word I'm looking for? It's variable about whether a person has decision-making capacity, especially with cases of early dementia, and especially in cases where someone's on medications or on a ventilator or whatever it might be that has them not able to be clear, even in their examination as a what they call mini mental, of understanding who they are, what they believe, etc. Anybody's look at those, the point at the end that says, in summary, a good patient advocate must be able to serve as your voice and honor your wishes, not theirs. They'll be willing to make decisions which would not be their decision, but have been clearly expressed to the patient advocate as the patient or the person's decision. Anybody see anything in the bullet points there that you want to ask about or follow up a question with?
I do. I have one.
Yeah.
The second point from the top group where it says it is also important. What happens if they haven't signed it yet, and something would happen?
If the patient
Patient advocate.
hasn't signed it yet, yeah, without signatures, it's not a document. It has to
Oh,
be dated.
even if they agree. Okay.
Even if they agreed to say, oh yeah, mom, I'll be your advocate if the time ever came. If they didn't, and we're going to get into this with the nitty gritty later, but it must be signed and dated and witnessed when the person executing the document, the patient or the loved one, executes the document, and it must be witnessed in Michigan.
Ah,
In a lawyer's office, it can be witnessed by lawyer office staff, or even the lawyer, him or herself. But if it is, if it's not, if it's a form that you're just filling out, it can be absolutely legal, but it's not legal, and we'll get into a lot about it, about who has to witness the signature.
okay.
Then you can have it all done, but the advocate or advocates, if there's backups, successors, filed backups, etc., if they haven't signed to accept it, they have no voice either.
Oh, okay. That was the question. Okay. So I've signed it, but they also have to sign it. Okay.
It's a moot point. Both signatures have to be signed and dated. They don't have to be, the advocates doesn't have to be the same date as the person executing the document. But we'll get into all that nitty gritty later on.
Do advocates have to be witnessed, their signatures?
No, they do not.
Okay.
There's no witnesses for the advocate accepting it.
Okay.
Let's move to the next page.
Dave?
Yeah.
Dave, the third point back there, they're backing up, where in order to refuse or stop life-sustaining treatment, that would mean even if I've talked with my patient advocate and the patient, I've said, I do not want, say I want to be a DNR for if I'm found unresponsive. Then that's clear. But then if I haven't also written it in my patient
But the law says, Tom,
directive, it wouldn't hold.
what the law says, Tom, is that and we'll get this when we see the form, especially next week, but we'll see that the law says, and it's phrased this way: the patient advocate must show in a clear and convincing way that they have been given permission to withhold or withdraw life-sustaining treatment, even if that withdrawal, including when that withdrawal would cause the person to die or result in death.
So it's not enough to have it verbally clear.
No, just to say that's my wishes, and that's why the form has a specific box in it where you can prove that you had that discussion and that you're giving the authority of your advocate to make that do not resuscitate call, withholding or withdrawing life-sustaining treatment in a specific case has to be, and they call it well, they call it the clear and convincing rule in Michigan. It has to be clear and convincing, and who knows exactly what that means. But the form has interpreted to be, it's in the form. It's in the form that you're giving permission, and we'll see that in the form when we look at the form in a better way.
Thank you.
On this page, I'm not going to go through much of it other than things that we've said before of what authority the patient advocate has, and at the bottom, what they have permission to do. And I just let you read those bullet points to yourselves there a minute. They can do, and this is right out of the state law, basically, what a patient advocate can have authority to choose or not choose. Let you absorb that for a minute and see if there's any comments or questions that come up from that. I'll make a comment about the first set of bullet points in the middle part of that page. The third bullet point down says fears or concerns you have about illness, disability, or death. This is when we do when Making Choices Michigan, and I haven't really mentioned them yet. They're the subsidiary of MyHIN, which is Michigan Michigan Health Care Information Network. Health Information Network. It's a new organization to us, but Making Choices Michigan, who produced this form, the acronym for that is MyHIN.
Code 250 to green
Sorry.
lot front entrance. Code 250
Yeah.
to green lot front entrance.
Sorry, I can't turn off the overhead things in my office here. One of the people that facilitate these discussions and help people fill out these forms often begin with this question: what experience have you had in your family about a person's end of life that you either valued or would not want to repeat? And this is kind of getting at the fears or concerns you have. Well, when Aunt Mabel was sick, they didn't do such and such and such and such, and they should have, or they did such and such and such and such, and they shouldn't have. And those family stories pervade family systems about who did right in making it a good death, as they say, or not a good death. And a lot of times it's very productive for a patient doing these forms to have that discussion with their advocate. When Johnny or when Grandpa Dave had such and such, we did this and that felt just right. Or this happened to him and it was a nightmare. And I wouldn't want that for me, for all the whatever. So that's often a place to start a discussion with a person and their advocate is, what wouldn't they want? Because it didn't go well and we didn't want that for us. Or that made it just peaceful and great, and we want that when it's my time. So I make special note of that. Anybody else have a comment or question on that page before? We're not going to go through each page here, but is there
I have a question. So on the last bullet on the page, it discusses whatever setting is most appropriate in Michigan or any other state. So does that mean that this patient advocate paper is valid in DC or Virginia or wherever?
Yes, that all the states have reciprocity with advanced care planning documents. So if someone comes with a living will in their purse from Illinois, which they do have in Illinois, I'll explain a little bit later, or maybe in next session, why Michigan does not have a living will statute. It doesn't mean they ignore living wills or don't think that they're good, but they put all their eggs in the basket of durable power of attorney for healthcare, not in a living will. A living will, and I'll explain more later, is basically a laundry list of what you want or didn't want. But there's nobody can anticipate all the nuanced choices that are made in healthcare and put it all down in writing. So Michigan has said, we're going to put our eggs in the basket of a person who you legally assign to be your mouthpiece, to be your spokesperson. And so if somebody comes from Illinois with a living will in their purse, it's going to be honored to the best of our ability as their wishes. But if you're doing a document, you kind of have to use a durable power of attorney for healthcare form, patient advocate form in Michigan. There's a lot of different forms. There's a big push maybe 5 or 8 years ago for this form, which was used nationally and still is, I believe. And it's not a bad form. It's called 5 Wishes. And it's kind of a hybrid between a living will and a DPOA for healthcare. It does help. All the documents help, but the main thing that helps is having a person assigned, in my view, and to talk with them a little bit early and often about what you're, 5 years ago when we talked about this, I'd said I'd never want that, but I've been thinking about that recently, and I think I would want that. We can, and you change it up with your advocate as you need to. It's not one and done, and it's not all in writing and nailed down when it's a person that you can converse with and educate. Let's just look briefly at 2 or 3 of the other pages. I think there's 2 more, 3 more. We're going to skip this because we're going to get to that later. After you've done a form, what it's all about. This form also has a part where you can talk about burial and cremation preferences, and we're going to talk about what that means as well later on. And then this last part is just who holds a copy of this advance directive, so that people know where to find it if it's in various locations. And we'll go on to explain how a copy is just as valid in the law as the original, and what that means to have. If you have copies out there, but you change something, it means you got to gather up all the old ones and discard them and substitute the new ones. But we'll explain all that later. The last thing I want to say about this document is at the bottom there, when it talks about Michigan Health Information Network, otherwise known as MyHIN, or Making Choices Michigan. That website there it's listed there is the one that will have the latest and the greatest final, all the T's and I's the way they should be, I'm told, in 10 days from now. So we'll see if that actually happens. But as we move into next week as well, we're going to look at that form, and I'll explain how you can also fill it out online. It's got a fillable form where you can type information as you go. And it's really handy to use it in that way. And we'll say a lot more about that next time for sure. So we can go back to the other PowerPoint. And do I need to bring it up again, or do you?
Yes.
I need to bring it up again?
You do.
Okay.
So I kind of took over for you. There you go.
Okay. All right. So some things that are important to remember from some of that planning process things. And again, I repeat myself, but I hope you get it. A durable power of attorney for healthcare, or sometimes just called medical power of attorney, is very different than a financial power of attorney. They have nothing to do with each other. Now, it could be the same person that you're assigning to be your healthcare decision maker and the person who's going to get your bank accounts in order after when you can't manage them yourself. But it might be a different person. And your healthcare medical power of attorney doesn't have any say, none, zero, over real estate, insurance, bank accounts, business holdings, anything of that nature. Anything that has dollar signs in front of it, they don't have anything to say. Okay, but the power of attorney for healthcare has everything to say about what choices are made. for healthcare decisions. And it's important to remember that a healthcare power of attorney or durable power of attorney for healthcare doesn't take effect until doctors confirm that we lack decision-making capacity. If there's any doubt, it has to be in the patient chart, okay? It has to be documented in the patient chart. This person, at least for today, does not hold decision-making capacity about whether they go off to that emergency surgery or have that heart catheterization or gets transferred from one nursing care facility to another or anything. If the person can make your own decision, if we can make our own decisions, whoever's on that sheet, they can try to influence us, they can try to talk us into something, but they can't decide for us in that way. If you've made a document like this, you can rescind or fire your patient advocates anytime, either in writing or verbally. You can just say, no, I'm done with you. I don't agree with you anymore. You're done. If anybody else hears you in the medical field, they will consider your voice ineligible to make a healthcare treatment decision. And conversely, a patient advocate can say, I'm out of here anytime. This is not what I signed up for. That this healthcare decision is too complex for me and I don't want a part of it. And for whatever reason they want, they can resign and take themselves off the situation. And they can, now hopefully there'll be a backup, a successor that has been named by you to take over in case the first person resigns, doesn't want to do it anymore. But some cases, that's why they hope that there might be more than one appointee as a patient advocate and more than one who have accepted the responsibility to be a potential patient advocate. So I'm going to just reiterate the different kinds of advanced directives in the state of Michigan and other places, just by way of putting ourselves on the same page again. We've been talking about the preferred one in Michigan, the patient advocate durable power of attorney for healthcare. The reason why is that there's a person who you've coached up to be your potential caregiving treatment decision maker if it was ever needed. And you can't, in my view, and I agree with Michigan's view on this, that you can't anticipate everything that might happen and put it all in writing. You can talk about the values and the trends and the goals and the values that are important to you, but the nitty-gritty is often nuanced, and you need a person to sort through that and say, at the end of the day, I think he would want blank. The second kind of an advanced directive is a living will. That one is not preferred by Michigan law, at least. It lists in detail all the treatment you would want or not want. Sometimes that can be, I've seen one that was 5 or 6 pages long of just, if this happens, I want this, and if this doesn't happen, I don't want that, etc. Now, that's not bad to know what the patient's values are. It doesn't hold the same weight as a patient advocate. The other kind of advanced directive is specifically about organ and tissue donation. This is a separate animal, but the form that you've been sent and the one that we're going to talk more about next week has this designation of anatomical gift advanced directive right in it. It's part of that. It's a separate document, but it's included in the main advanced directive form, and the one that my Making Choices Michigan has put out. And in many of the cases, and in cases that you might have from your own attorney who drew up an estate plan for you, it would often have organ and tissue donation in the estate plan there as well. But technically, that's a little bit, it's a standalone little document that is part of other documents. So you don't have to have an advanced care plan, a durable power of attorney for healthcare, to have an anatomical gift. And that's why we have the ability in the Secretary of State to make the organ donation checkbox and say, yeah, in principle, I'm open to using whatever tissue, or if the cases of a beating heart, an organ donation, if that's part of my value, my values. So that we'll get at why that's in there. But now let me look at this parentheses at the end of number 3 here. Optional and supported by Michigan law, but this directive about organ or tissue donation must be followed if you are a candidate after your death. That's right in the law. So if like you, if like me, you have a little red heart on your driver's license at the bottom right corner, and I'm in an accident on my way home on my bike today, and I'm brain dead, and I've said they see my little red heart in my pocket on my driver's license, they're going to assume that I'm giving permission to go down the road of organ and tissue donation. And my patient advocate or my next of kin, if I don't have a patient advocate, doesn't have anything to say about it. Now they can gripe about it, but if it's on your driver's license, they can't undo it. And so people don't realize that in the state of Michigan when they're signing up for organ and tissue. It's not just a hypothetical, it's like a legal directive that says, I will be considered a candidate. Now, you might not be a candidate for whatever reason, but they're going to consider you as a candidate if the little red thing is on your driver's license. And then it goes by that, your autonomy. And the next one is called a out of hospital do not resuscitate directive. Now, I'm going to ask Susan to put up that one on the screen, which is number 1 on the other documents. And we're going to see how this is different than an advanced care plan DPOA for healthcare. This is not a patient advocate designation form. This is a doctor's order. Okay, so when this comes up, we're going to look at this. And
I'm usually so much faster than this. Can you tell me the name that you have it? Is that the post-draft example? It looks like it's named something different.
out of hospital do not resuscitate order. And there's a number 1 on it, and written on the top right.
Got it.
Anybody have any questions about these 4 so far, that these types of advanced directives, or anything about that?
I've got a question. I put my patient advocate form together in 2003, and I haven't changed any of my attitudes. Is there any reason to update it?
No, there's not. It's they will look for the latest dated one in case there was a previous dated one that didn't get taken out of circulation when you redid it. But if it's all the same, they're not going to care if it's now some of the forms, but the form that we're going to be looking at next week does not have this. The previous form had, or a couple of forms ago, had a thing where you could say reaffirmed and then redate it. This one doesn't have that, but if you just write on there anywhere, reaffirmed March 24, 2021, that will go well to for the people that are looking it over if it was ever in need to see how
Yeah,
current.
I've got that on my form.
The reaffirmed?
Document or reaffirmed by me.
Okay, that's a good thing to have.
2019.
Excellent.
Is this, David, is this form we're about to talk about the same thing as what some people call the POLST, P-O-L-S-T?
Nope, but it's very similar in intent. And maybe that'll be a reason, Susan, to put that other one right after this one. The one that said number 3 on your lists. Let me just say a word about what this is. I know our time is kind of going fast here, but out of hospital, do not resuscitate order is a physician's order. 98% of the people, including everyone on this call, this will not apply to. It will include someone who is of chronic condition and failing in health, very elderly, or terminally ill. Okay? I don't know what your definition of very elderly is. I know a person who was 90 that had one of these and was otherwise in fairly good health. But what this says mainly is this. If I'm walking down A Street and I fall over and my heart stops or my breathing stops, and the ambulance and the person out in front of Frisk Outfitters calls the ambulance, and they come and find me without a pulse and without breathing on the sidewalk in front of Frisk's store, they have permission not to begin resuscitative efforts. The difference in this form is that, and I won't go through it all, but if you have questions about it, I'd be happy to answer them in that way. This one needs a physician signature. A durable power of attorney does not need a physician signature. They only are your appointment of your person who would be your thing. But you see in the middle between the two big boxes, two big lines there, it says physician signature, date, and printed. And it also has to be witnessed by the two people that are at the bottom of the page who have to also date and witness and print their name. And this is right out of Michigan law. And this order, a physician's order, is effective until it is revoked by me. I understand that this order does not have to be permanent and may be discontinued at any time I wish. But being of sound mind, I voluntarily execute this order, and I understand its full importance. It says basically, if I'm outside of a medical facility, in your home, in your apartment, on the street, at a Hope College basketball game, and your doctor agrees after discussion with you that it's reasonable for you not to be attempted. An otherwise healthy person wouldn't put this into effect. But if you've got advancing cancer, COPD, CHF, all these things that might be progressing, and or stage 4 lung cancer, whatever it is, and you decide along with your doctor that, in conjunction with discussion with your physician, that you would not want to be resuscitated or attempted to be resuscitated, and you may consider this. But like I said before, 95% of the people this does not apply to. Okay?
How does, if using your example, how does the person who finds me know that this exists, or how do they find out about it?
That's an excellent question. When there's times where it's not known, first of all, if somebody does have this and they live in a place, they might put it on the refrigerator. In fact, it was for a while there was a movement to have people put advanced directives in a plastic bag in the freezer of their kitchen, and the first responders would look for a plastic bag in freezers that had paperwork and pull it out, and there it would be. I haven't heard that now for a while, so that's one thing. Either you have it on you, or somebody knows you have it and says, hey, it's in her purse. She always carries it in her purse, and you pull it out. Or more frequently, and a better thing is, and it says, write this in the form, that upon executing it toward the bottom there before witness signatures, upon executing this order, the individual has or has not received an identification bracelet. Now, and they, please circle has or has not identification bracelets. This law says that you must have markings on you, or it's highly recommended that you order a do not resuscitate bracelet that you wear continually. And that in Michigan law, that has to say also your physician's name on the back side of that bracelet, and their phone number. I can get, if you're interested in that, I can get that information. There's specific things that have to be on the bracelet. It has to say Michigan do not resuscitate order on the top, on the front, and has to have your name and the physician's name and the physician's phone number on the bottom, on the inside of the bracelet. And these are ordered online in Michigan in a certain way that I could tell you if you're interested.
David?
So what David is recorded at the hospital?
Say that again, please.
Don't you have a copy of this at the hospital?
We will have copies of everything that you execute that you want in your file as your patient record. And we'll get into that next week about if you do a document, if you have a document from your attorney now, or you're redoing a document or using the new form that we're going to talk about next week, we are encouraging people to put a copy in Holland Hospital medical records or any other hospital system medical records. Put one in your primary care physician's office. And I'll get into all that. And of course, the advocates each need their own copy.
So if that is done, do you have to carry it with you, or would the ambulance contact the hospital?
If it's a do not resuscitate out of hospital, they'd be looking for a bracelet. If they didn't see a bracelet, I guarantee, unless somebody is waving the form in front of them that they somehow was there, they would attempt resuscitation and bring you to the hospital.
Thank you.
But if they saw this, either the paper or the bracelet, they would be legally okay to not resuscitate you on the street.
David, do emergency departments have the right to be able to contact, say you don't go to Holland Hospital, but you're in another state and you don't have the documents with you.
Right.
Do emergency departments have that right to access that?
Absolutely. And if somebody says there's an advance directive in Arkansas and they know it's at such and such a hospital, we will do diligence to reach out to their medical records and get that faxed over or scanned and sent over to us. So that we know who we should be talking to, or if they've made it clear in a living will, for instance, of their values about things. So, but we do quite often try to dig up. The same thing is true. What I mentioned before about reciprocity, if you have a document, now I have in my wallet, because part of this Making Choices Michigan thing is I have a little card in my wallet that says, notice, I have an advance directive. And it lists who my advocates are. In my case, my wife is now my number one and my nurse daughter is number two. And that's on there, and where they can find it at Holland Hospital Medical Records, etc. So I carry that, and a lot of people, there's a wallet card that will come out on the MyHIN page when it comes out. It's already there, but it'll be updated soon. And you can print one of those out and have it with you that they know you have an advance directive. If you're of the demographic that might use this out of hospital form, then pretty much you're down the road on this a long way to know that your expected life is short anyway, and you are in a critical kind of deteriorating situation, or you're 101 years old, and that they have your permission, along with consultation with your primary care physician who signed it, not to attempt resuscitation on the street or at the basketball game or wherever it is. And yeah, so.
Dave?
Yeah.
Dave, two things. One is it's important for people to understand, for all of us to understand, that with if you keel over on the street and the emergency techs show up, they are not going to call somebody on the phone before they start. They're going to start resuscitation unless you got a bracelet. And my second one is my mother, who's 98, doesn't want to have one of these 5-pound prison bracelets, as she would think of it, on her wrist. So she's got one with the proper emblem, but I don't think it's got the doctor's name and phone number, so it's not valid. Then is that what you're saying?
Well, according to the law, I've got the statute that I could show her or you, because it says what legally has to be on it for it to be valid. Now they might honor it anyway without all the bells and whistles, but the law says that it needs that stuff.
Okay, thank you.
That's just quickly, if we can, Susan, go to that other My Post document, number 3 on the thing. All right. This also says draft on it because it's not the law yet. It is very slowly, pre-COVID, working its way through the legislature in Lansing. This is a state document, but it's very similar to a movement across the country for what they call a post. And that is, in this case, we call it My Post. Some states call it Polst, P-O-L-S-T. In our case, it sounds for Michigan, a physician order for scope of treatment. That's what Michigan legislature is calling it. Michigan physician order for scope of treatment. And this is similar to the out of hospital, do not resuscitate order. But I'm not going to go through this form. We can, maybe Susan can keep this scan or scan it and have it available to email to people that are interested. This is not the law yet. It's coming.
I can certainly do that. If
Okay.
you want me to just commit now, I can send it out to the class.
Okay. If you would do that for this, maybe 1, 2, and 3 of those 3 documents.
I will.
All of them might be background they might want to see at some point when they pull it out of the drawer and there's not talking about all this stuff.
Sounds good.
But this is quite ABCD here. This is also needs a physician signature, and it's quite directive about how aggressive to be in treatment for medical interventions, for CPR, for all of that. And this is similar function to the out of hospital. But this will be seen and be used more in a standardized way in all nursing care facilities. And it will, in my view, when it comes, and it's like making sausage, you know, making laws is like making sausage. It's not pretty. And there's certain constituents that are kind of holding up the train on this right now. But this is coming from everything that I've been told. And I think it will be one of Michigan's best used advanced care planning things to make it clear what somebody toward the end of life or an advancing illness wants to do or not do. And so when those come to you by Susan's attachments later on or between now and next week, you can look at that or answer any questions further. Is there a second page on that one, Susan? I think there is. And yeah, so we'll go on. We'll go on. All right, so I'm kind of winding up here, and then we'll have a few minutes to tell what's going to be next week and to reiterate a few things here. So this was done several years ago now, 2012. That's longer than I think. But at that point, they said 82% of people say it's important to put their healthcare wishes in writing and name a legal patient advocate. But 23 to 25% of the people in the population have actually done that. Which I think since 2012, we're at 26 or 27% of the population.
Are you intending to show your PowerPoint?
Yeah.
Okay, yeah, you go ahead and push the share button again.
I see what I did. I'm sorry.
That's okay. I kind of steal the controls and then it's just a manual process with Zoom.
Okay. Okay, I have it up on my screen, but where's my share controls?
So look for your controls. Go anywhere on the screen that you can see your Zoom controls and hover over that. And your green share screen button should pop up. And if it doesn't, I'll go ahead and pull it up real quickly and tell me what slide it's on, and I can share it real quickly.
Okay, I'm trying to share. I'm trying to find it again. Let's see. I think this is it. That's not it.
don't apologize. It's real, it's tricky. It's tricky when you have a lot of stuff up on your computer too. Why don't you tell me what slide you think
Yeah.
you're on, and I'll share it and I'll just navigate it for you.
It's at slide 18.
Okay, I'm almost there. Give me a second.
I tried to get it back.
So what I'm gonna do is move, I've got a bunch of stuff up on my screen, sorry. Slideshow, play from start.
Let me say a word while she's doing that. Next week, we're going to look at the MyHIN Making Choices Michigan form that you were sent. Even though it's not live yet, it soon will be. And we're going to be kind of putting these discussions into how would we do a form like this if we were doing it. And we're going to invite you, if you have already appointed a patient advocate or successor backup advocates, to invite them to attend this session as well. Because we're going to be talking about the kinds of things that people will talk together about to make this a useful thing.
So if everybody could just look at the portion of the screen that has the main slide. I just didn't have, I can't do it on the fly. So that's the main slide that is number 18 for you.
Okay. That's not the one I thought I had.
Okay.
Let's see. Is there a couple above it? Oh, that one.
Here we are.
So 82% say they should do this. 23 to 26 or 7% have actually done it. Next. You could do this, as we said before, at a lawyer's office. You might have already done that as a part of an estate planning package. But you can, using an advance directive form that is witnessed and meets state's requirements is important, and a variety of forms in Michigan meet those requirements. And we're going to be talking about the Making Choices Michigan MyHIN form. Important things to remember, you might want to, you may appoint a primary patient advocate or alternate successors backups, but only one patient advocate can be an active advocate at a time. So if I had my wife, I have my wife and my daughter as my primary and successor advocates. My wife technically has the only say for my healthcare choices if I was unconscious or injured or whatever. And my daughter wouldn't be the primary person. Now she can consult with my wife. They can decide together, but the physicians are only going to listen to my wife, unless she resigns or says, "I can't do this. I don't want to do it." Anna, it's your trial. It's your time. So then it would go to the next person. Your patient advocate cannot act on your behalf until they officially sign an acceptance form, which is part of the form as well. It has to be signed and dated, but not witnessed. And then to start talking about it. This is where we're going to basically leave. We're going to pick up here again next week and then talk maybe even with your patient advocate or advocates. If you share your link with them, Susan and Kim told me, they could listen in just like you are on this call, on this session as well. Am I understanding that right, Susan?
Yes, I want to make sure I'm unmuted. Absolutely. So what he's saying is obviously, if you want to bring a guest to the class, you may. I can also provide you with a link to the virtual classroom that you can forward to them. And we will just basically let anyone in that we see as associated. So please invite your advocate to listen in so that they can hear what you're hearing.
And if you have already a document, either a form that you did without a lawyer or a lawyer's estate planning form that talks about healthcare proxy decision-making, or your values about what you might want or not want. If you don't have that with you today, maybe find where it is in the file. Hopefully it's not just in a safe deposit box, but in some place where you and other people might know where it is. And have that in front of you too, if you already have such an animal. Sometimes I do this with groups at the hospital, like do it with the pulmonary care group, pulmonary rehab group. And they will, where was I going with that? I'll do that with that group, and they will want their loved one to attend that session with them, or their patient care advocate to attend that session with them. And we always say that's okay. Other times people say, I've already got a document, but you know, it was 15 years ago. It's kind of in legalese. I really think I need another a version. Can I do a new document? And that's, of course, you can do that too. And you can do it as we're inferring here. You can do a document like this without a lawyer, as long as it has the right witnesses. We talk you all through. And you can do it in a way that helps people communicate about their values and wishes ahead of time, so if it was ever needed. So we've got 3 minutes left or something like that. Does anybody have final question or comment or suggestion that would make next week go well?
David, it's Pat Denner. Hi. I just wanted to say, being a patient advocate is probably one of the hardest jobs you'll ever agree to do. And it's one that's taken on with love. So even if you've done all your paperwork and you've, designated your patient advocate, it would be such a gift to that person to contact other family members who are close enough and would have an opinion, and go over what you've decided and say, are there any questions or concerns? Let's talk about them now. Because as you know, an ICU is not the place to be discussing who did mom love best.
Excellent point, Pat. Any other comment or question as we go?
Yes, I have one. In terms of the Hipaa laws, when you get a form from your physician about who has access to hearing, getting prescriptions for you, getting summaries of reports and stuff like that, is there an advantage to have the patient advocate have access as well?
Yes, they by law, they have access to anything that you would deal with, they can deal with, but only if you're not able.
Sure.
If
Okay.
it doesn't take effect unless you were deemed to be incapacitated or without decision-making capacity. So, but you can put, of course, the Hipaa laws will allow you to give a password or a permission to get medical information at your permission, even if they are or aren't yours. So it could be your patient advocate that can get your, well, you've got this coming up, should we go this direction or that direction? Or can I get if you've given permission, they can get it. But if you've not given permission, then even a patient advocate would get it only if you were not able.
Good point. Thank you.
I have a question.
Yes.
I'm wondering, I have all my legal papers in Wisconsin, and my medical records have been sent here to my primary physician. But should I transfer all those legal records to an attorney here?
Well, there's come back to where I don't even play a lawyer on TV. So I think I have to defer whether there's any advantage to having a local contact if they're available on demand or at request from Wisconsin. I don't know the answer to that. I'm sorry. Maybe somebody else is a legal person on the call and could answer that.
I'll check with my Wisconsin attorney.
David, can you hear me?
Yes.
What if all of your family live out of state and out of the country? How do you do the signature of the advocate?
They will, if you send them the sheet that says the advocate acceptance form part, that can get inserted into the booklet of your papers, even through a scan or a fax.
Okay,
You're
very good.
able to even do that. You can sign it outside this jurisdiction and have it inserted into your document, as long as it's appropriately added to the document. The other pages are taken out.
All right,
It
thank
can
you.
happen that way.
David, can I ask you a question? It's Louise Kenny. I was wondering if you're a patient advocate for someone who's in the hospital. I understand HIPAA and getting permission, but what would you recommend if this person is, obviously competent, but really struggles with understanding physicians and especially physicians with accents, et cetera? I found, for me, I get in touch with a medical social worker who's assigned, but is there anything in the hospital that might make it an easier way to get your name onto a list that you can be talked to or have things discussed with?
If
Thanks.
the patient is able, even in a minimal way, to say, I need some interpretation with understanding all this. I'm of sound mind and I know I'm of sound mind, but I just don't get it. And I need so-and-so, I need Louise to help me with this. And they put that in your medical record that that patient has given permission and you would have access to talking with the physicians, talking with the patient, being a go-between. It just means they have to approve it. They have to give permission for you to do that.
Thank you.
People all the time put a list of people that can call the nursing station for medical information. And when they call in, they're given a password. I mean, they're not given. The patient or someone with the patient sets up a password. And if that person that calls in knows the password, the nurse or whoever can have permission to talk with them about medical situation. Well, I think we're over time. I look forward to next week. We'll go through some forms and some important things, what I would call 25 things that you should talk to your patient advocate ahead of time about. And we'll have a discussion about that, and then we'll move into the form that is the almost official form for those of you that might want to do that. But even if you're not doing a new form and you have your legal stuff in order, it might be a way, prompts to help you talk together with your advocates or wider family or friends about your values for healthcare decisions for you. And so with that, I'll either turn it back to Susan or Tom and say goodbye for now.
Thank you very much, David. Great class. Look forward to next week.
Thank
Bye-bye.
you so much. And I will be forwarding everyone the 3 documents and also a link to the classroom that you can just forward the email directly to your potential patient advocate that would want to be on the next session. So you'll all receive that. Thank you so much, David. Have a wonderful afternoon, everyone.
Thank you. Bye-bye.
Bye.